So thanks for joining us in this session on Myside bias and legal advice. If you're here for anything else, now is the time to gently walk away. But if not, welcome, and it's great to have you. And frankly, before any further ado, I'm just going to run this very important video for those who haven't seen it, and then we'll see how it goes.
He's cycling fast and is wearing no helmet. Ahead of him, Dan parks his car. He opens his door without looking. Bob crashes into the door, falls over, and hits his head. He is injured and sues Dan for $100,000. So Dan and Bob talk to their lawyers and ask, what will the judge do here? How much of the $100,000 will they give to Bob? Should we settle? Given that both lawyers are looking at the same facts and same rules, there should be some agreement, right? We asked 166 graduate students of law to take sides. Half represented Bob, the other half Dan, and we asked, what award is the court likely to give? Here are the predictions. Red squares are representatives of Bob, and blue are representatives of Dan. You'd expect some noise in these award expectations, but not systematic differences between the reds and the blues. Remember, they're all looking at the same facts and rules. On average, Bob's representatives thought they would get $72,000 and Dan's that they would only pay $43,000. These differences are highly significant and probably mean that Bob and Dan would not settle, although they probably should. This is Myside bias in litigation.
All right. Now, before we start with the event itself, there are a few ground rules. Number one, and this is important, we have tested and confirmed nobody in this room is biased. So we can all relax. It is 100% guaranteed. It is the other lawyers that are biased. Just saying. Second, FYI, I understand the event is recorded. So if you want to say something silly, you're welcome, but will be available on request. The Q&A is not recorded, and therefore, if you are so minded, please keep the really, really horrible things till the end. Finally, and before we give the floor to Michael to introduce his study and then move on to the panel, I'm both quite frightened and quite excited about these findings. I'm an external lawyer. I don't think I'm biased. But these studies show that there are other lawyers out there that are biased. And so today, what I would really ask the room and my panelists is to test the study, to convince ourselves of the findings, and then think about how that impacts our professions, our clients, and the solutions that we can have to resolve it. And without further ado, Michael, please can I ask you to present your study? Thank you.
Okay, thank you, Katya. And welcome, everyone. And first thing I want to say is thank you to the British Academy and the Leverhulme Trust that funded this. It's a great honor to have that funding, and we've done our best. So what I will do in the next 15 minutes, I'm going to try to rush through a kind of overview of what we did. And the roadmap is what's Myside bias? What is it? How does it apply in legal settings? Why should we care? I will talk about a few aspects of how it works, because we know a bit about how it works. It's kind of a complicated thing to understand how it works. And I'll try to explain some aspects of it. Then what evidence we have for it. And then, that's our studies. And then we'll move to, can you suppress it? Can we get rid of it in some way? And what the evidence and research shows about that. And then we'll have the debate about the implication and whatever else you would like to debate. So what is it? It basically means Myside bias is a quality of outcomes, a quality of, say, predictions or evaluations when people look at evidence or come up with evidence in a way that it doesn't endanger a particular belief that they care about. Yeah, so you have a particular belief about something, And that can be about anything. It can be about an outcome of a legal case. It can be about abortion. It can be about whether, smoking is bad for you or not bad for you. And if you care about this, you're more likely to be biased. And the way, when you look at the evidence for it and against it, your evaluation of this evidence is skewed. And it happens in all kinds of domains of judgment. It affects everybody, irrespective of gender, age, education, intelligence, if you're an expert or not an expert. In fact, intelligence makes it worse sometimes. And it also is a major barrier to consensus or dispute resolution. Because people who have Myside bias views, they honestly cannot see the point of the other side. They say you have to look at it from the other side's perspective. Very often that's like an important prerequisite to resolving a dispute, and people can't do it. They honestly cannot do it. They're trying, but they can. We basically. And one of our questions was, can lawyers be Myside biased? Isn't there a bunch of reasons why they should be, including that the law mandates them to be zealous advocates, that they work in groups, that if you are actually biased, if you are actually convinced you're right, you will be more convincing in court. There's all kinds of studies that show that. So there's a lot of reasons to believe that lawyers could be biased, and there's some research. Now the next question is, how does it work? And this is a challenging thing to do, to explain this, and I will try my best here. So this is something called Shepard's tables. It's a famous illusion. And the task in Shepard's tables, you have to bear with me here. You'll see how it's relevant for lawyers and Myside bias. But the task in Shepard's tables is, are these the surfaces of these two tables, the tops, are they the same? That's the question. Are they the same? And when I say the same, I don't mean is the square footage the same. I mean, are they identical? So if you put one on top of the other, would they match perfectly? Or would one be narrower and longer and the other one shorter and wider? So if you just look at the surfaces, ignore the thickness, ignore the legs. Okay, so that's the question. And the answer to this is, it depends how you look at it, right? If the impression is that they're different. But if you measure, they're the same. Okay, it's an illusion. And the reason why it is, it's sort of perception, psychological perception, is our brain, when it interprets the data, cannot disallow for the thickness and legs. So the surfaces are identical. And if you don't believe me, you can Google it. I have printouts in classes when we do this. There's always unbelieving Thomases, and we bring scissors so someone will cut them and compare. They are actually identical. Now, why are we using this? This is to illustrate the two types of mental processes generally under this thing called dual process theory in psychology. Two types of mental processes the brain uses to evaluate things and perceive stuff. Okay, and one is the one that we normally associate with thinking, which is, if we want to really know if they're the same, let's measure. And that is controlled. Okay, you need intention, control. You take a ruler, you measure, you write down, this is 18 centimeters, the other one also 18 centimeters thick. And that's one, it's kind of procedural, controlled. The other one is just an impression. You look at it and they look different. And we're not aware, what's important here is this, we're not aware of the calculation that happened. And there's a lot of calculation that happened, right, in the brain to facilitate this impression. We're not aware of it at all. It leaves no memory trace. There's no control over. We have very limited ability to audit it. So if we look at it, we say, oh, they're different, but let's check. And we check and we say, oh my God, look, they are the same. And then we look at them again and they look different. They don't start looking the same because we measured them. Does that make sense? It's not like there's a loose screw that you can screw and then it'll be fine. So this impression, immediate, I'm going to spend just a little more time on this because it's so important, I think. The impression, it doesn't just happen. It just happens for us because we're not aware of the process that gives rise to it. I mean, there's a lot involved. Light hits your eyes, it's converted into electricity, it goes to your occipital lobes at the back of your head, and then your brain kind of goes through a lot of computation to come up with this impression. Does that make sense? We're just not aware of the process. We're aware of the result. Okay, why is this relevant in the context of this bias? Because this processing that gives rise to bias as a systematic deviation from where it should be. So all the reds were a bit more on the right than all the blue dots. This processing of information, okay? This bias processing of information where we underweigh the evidence that doesn't support our preferred hypothesis and overweigh the info that does is an automatic process. You don't do this on purpose, okay? And this brings us to another point that's really important that Katja kind of highlighted as a joke. But Myside biased opinions, they don't mean unethical behavior. This is not something where you know that your odds of winning this are really 50-50, but you're going to say that they are 60-40 because you want to win a pitch. Or you inflate your expectations of reward in a negotiation to anchor, your first offer, or like an advocacy narrative. These are honest opinions. People honestly, in their heart of hearts, believe this. Yeah, because the way they look at information, because of the role they're in. And in the real world, with lawyers, judgment, other things can interfere, such as how they're paid. Maybe if you're paid per hour, there's an incentive to work many hours. If you need to be optimistic, otherwise your client won't hire you. The client pressure to behave a certain way. That's not what we're looking at. Yeah? That's been researched under other headings. One is unconscious unethicality, but that's not what we're looking at. We're looking at honest opinions, best efforts basis. The next point is, why do we care? Well, we care because, as you've seen Bob and Dan study, they won't settle, right? If Bob thinks they'll get 70, they won't take 50 in negotiation. If Dan thinks he's only going to have to pay 40, he's not going to pay 50. So this settlement range should narrow, and overall, the cool thing about this, you can actually check this, because if there is prevalent Myside bias out there, then we should see reduced settlement rates, right? There should be less settlement. And yet we have this kind of idea that 90 to 95% of cases settles. That's a common thing, and it's a myth, because this is what it would look like by countries. We have countries there, and this is a 95% settlement rate. 95, the green is settled cases, okay? If settlement rate were 95%, this is what it would look like. The red is litigations, the green is settlement. 2023 study looked at this, and these are the actual results. It's not 95%. These are different countries, have different settlement rates, but it's a lot more red than green. Except the Australians, they're doing something right. The very bottom one is Australia. There may be other reasons for it, not just Myside bias. That's important, right? A lot of things conspire, such as how expensive are lawyers. That's one of the big things. And whether the legal system has fee shifting, like the fee recovery. If you win, you get them back. That's a bad thing. People won't settle and so on. So yeah, this is why we should care. Now we move to evidence. This is our study, the basic study that you've seen. It's a part of it. It was sort of a bigger study. The key things, I'll go through it briefly, is the undisputed bits were the cyclist wore no helmet, the driver did not look. 100,000 is an appropriate award if it's entirely the defendant's fault. Okay, no contributory negligence, 100. The question to the participant was the judge going to award the claimant? That was the question. And you've seen this, these dots. And it shows that, the systematic differences between the two. This is another statistical measure. It's called the ECDF, so empirical cumulative distribution function. And it basically shows what are the odds of, if you pick something from the sample, of being something. The point is that these are everybody. The black line is everybody. And if you split this black line into defendants and claimants, if there were no bias, these two lines would kind of squiggle all over each other. They would be together. There wouldn't be a difference, but there's a difference. You can see they're very different, and the gray area is bias. You have a very nice illustration of significant bias here. Now we also asked them, this is not in the video, this is new stuff. We asked them, look at these arguments, and then we gave them 8 arguments, some for defendant, some for claimant, such as, it's not required, it's not a law to wear a helmet, so that cannot be used as an argument for contributory negligence if the person didn't wear it, something like that. And the participant had to rank this, how convincing is it to a judge? And then we said, okay, now we've seen all the arguments for both sides that people commonly use. Did you change your mind, about the assessment? Did you do that? And we also asked them, why don't you estimate what you think the counterparty thinks they will get? And that's important later when we talk about debiasing, but I'll just give you some insight now. Well, these are the arguments ratings, and for every argument that supported the claimants thought it was more convincing than the defendants thought. and the other way around for the defendant's arguments. So for every, it's not, usually you'd use averages. Here you don't have to average because each and every argument there was a difference. So for example, these guys here, that's arguments for claimant, favoring the claimant. The black bars are claimant's estimates. So for the first argument, the claimants thought it was 5.4 convincing, whereas the defendant thought it was, medium 4. Either convincing, not really great, for every argument, and it's flipped for the defendant. And the estimates also, if you look at arguments for one side, arguments for the other, another estimate, bias everywhere. This is a particularly interesting thing that we did. There is a phenomena called bias blind spot that goes often hand in hand with Myside bias. And what is bias blind spot? Bias blind spot is when I am quite good at seeing bias in you, but I remain oblivious about bias, the same bias probably, in me. Okay? And 1/4 of the participants said, the counterpart is what they expect in court is the same as what I expect. These are not biased. Maybe they were just lazy. We're thinking it was lazy because it was possible to click the little box there. They didn't have to drag a slider. Maybe they really weren't biased. But 3/4 were. And the interesting thing about this is this, and you have to work with me here because this is somewhat complicated. So you just look at these two bars here, right? So this gray bar is what the defendant thinks the claimant's estimate will be. And they think it will be around 70,000. And the black one is what the claimants actually thought, and it was 70,000. So you can see the defendants are right when we ask them, what do you think the other side thinks? And then you look at this one, that's the defendant's actual estimate. And that shows that defendants see the bias in the others, but see, it's them being biased. The crazy claimants, they think they're going to get 70, whereas we, unbiased defendants, know we're only going to have to pay 43. Does that make sense? So they're right about the bias in others, but that does nothing for their own. It's exactly the same for the claimant. This surprised us, this finding surprised us. That's how shocking. And it actually replicated. We did it in the other studies and applications with exactly the same results. So replications. We did three more studies to replicate it. The first two were just more complicated case, because Bob and Dan there was a half a page text. This was 25 pages, police reports, doctor's reports, everything, witness statements. 2 studies, baseline conditions, exactly the same results, literally the same. And then the second study that we're writing up now, with Toby, who is here in the audience, is the Vismoot. For those of you who don't know what Vismoot is, it's a very large moot court competition where the participants compete in an international arbitration case, and first they write a memorandum from one side, then a memorandum from the other side, then they practice this, they're coached on pleading, they plead many times to both sides, and in the finals, in the oral, they plead a number of times in front of tribunals and compete against other teams. So we ask them basically to predict what the arbitrators are likely to do and which client they represent at last. And irrespective of the fact that they all written memos for both sides, this took 6 months, okay? The written memos for both sides, they pleaded both sides. It's the last client that predicted the bias. So they're biased in favor of last clients for like 3 million or so. I mean, yeah. Can we get rid of it? The last part of the presentation, we tested 4 during the course of 2 years funded by the BA. We developed and tested 4 interventions. The first one was in the cyclist study, when people make their prediction of what they think they're going to get, and then we try to debias them, like pull them back from their extreme position into somewhere where it would be more reasonable. And we ask them, consider all arguments, consider the counterparty's prediction. Did your role bias you? How did it bias you? And then the big one is we said, imagine your estimate is wrong. Why is it wrong? Arguments, right? Why is it wrong? And then write down an alternative estimate. You can see that it converged a little. So these are the estimates after the argument ratings, and these are after debiasing. So it's a bit less biased, but it's still 21%. It still doesn't overlap, right? Then we had a separate intervention we called side switch. Side switch meant that we told them, okay, you're representing the claimant. Here is 25 pages of the document. Prepare for your litigation negotiation. And 45 minutes after, before they filled out the questionnaire, the predictions, we said, guess what? You're actually presenting the other side. The only reason we told you to present forever is to make sure you can see the arguments from the other side's perspective as well. And this is one of the ones that shocked us, because we assumed this would de-bias them, right? Is there a better way than manipulate them into actually thinking that they're the other side? But no, it failed. It removed bias in argument ratings, but not in award predictions. The second one we tried was dialectical, same result, removed bias in argument ratings, but not in award predictions. Here we forced them to kind of evaluate each piece of evidence, how it impacts both sides. And then the last one, which worked. And the good news, it worked. The bad news is it's very hard to replicate in real life. Is we basically told them, make your estimate. We have an estimate made by an AI, which we didn't have. We just told them we had it. And if your estimate is too wrong, you're going to lose your client and not proceed with the case. And that worked. So this is, in short, the presentation of the study. And in short, Myside bias is automatic and implicit, not unethical. It's significant and robust, replicates. It's resistant to suppression, and the only successful intervention is hard to replicate. But this accountability goal states interventions show some potential to attenuate bias. Thank you.
Thank you. If I can please ask the panelists to join us on the stage. Yeah, you're in the middle. All right, welcome back. Now you know why I was frightened about this study. But thankfully, I have an absolutely fantastic panel today to test the findings. Let's see if they're as good as they seem to be. But also to create a discussion. And I really do hope that we have thoughts from the audience. We have a number of very senior people in the audience. And it would be great to have your thoughts as well. But in the meantime, Michael doesn't need too much of an introduction. He's the star of the show. He is an associate professor here at King's College. He was a lawyer and then a principal banker in an investment bank in the city before joining academia. And he has a law degree from Harvard as well as a PhD from UCL in psychology, which is rather annoying. More annoying still is Professor Dan Simon, who is very kindly joined us from the US. Thank you for being here, Professor. He is a professor at the University of Southern California. And of course, he too has appointments both in Gould School of Law and Department of Psychology. Of course, he was visiting professor at Yale, Harvard, Columbia, Max Planck Institute in Germany, as well as a degree in Harvard Law, MBA in INSEAD, etc. So it's, again, an incredibly frustrating CV, and very nicely ties in with Lucas Mistelis, Professor Lucas Mistelis. He very naturally comes to the next because he has a real balance between the amazing work he does in the academia world, but also because he's a professor of transnational and commercial law in arbitration at Queen Mary, and we've all known the work that he has done at Queen Mary, including 10 of the 14 empirical surveys that we all refer to. But he is also a partner at Clyde & Co. And has been involved in more than 100 arbitrations as counsel, expert, and arbitrator. Very neatly, Suber, who sits next to me, Suber Akhtar, is senior legal counsel at, or I should say principal litigation counsel, but actually senior legal counsel at Siemens Energy. And so I will be cross-examining Suber today on all the impacts. But again, Suber, he's been in this field for over 20 years, in Siemens for 20 years. But also is, by the way, on the side, a barrister, which of course doesn't require much work at all. And last, but very much not least, my good friend Camilla Godman, who is the money in the room. We all need a bit of that. She is an investment manager, senior legal counsel at Omni Bridgeway. She is actually responsible for originating, assessing, and managing funded cases internationally. It just gives you a little bit of a sense. She's been at Omni for a long time. Before that, of course, she has a degree from Oxford, started as solicitor at Ashurst, worked at CARB, before seeing the light and joining just the second biggest litigation funder in the world, which I think has 3.2 billion in portfolio value. Impressive. Yeah. So with this in mind, thank you, all of you, for being here. Michael, before we ask the questions, this is unprepared. Can I just test whether we saw that you use students? One of the immediate questions that I have as an external lawyer is this really something you could replicate for us very expert, seasoned lawyers? And should we really be taking this study as seriously as it seems?
So we had student samples. We got a fair bit of criticism, not just that criticism, but there was a lot of debate about it in the peer review. That's a fair concern. There's good things about having students to sample and bad things. Limitations. One of the limitations is they're not experts in, say, personal injury litigation. So if you had personal injury lawyers that have seen cases exactly like the cyclist, let's say, they would have, probably there'd be a lot less noise. So you remember the red and blues that were scattered, right? My guess is they would compressed together, but I don't think the difference between the two groups with this. The reason is that there have been studies like that. They actually asked, Goodman Delahanty asked, I think it's a 2009 study, they asked real lawyers, the litigation lawyers in the States that were in litigation, what did they expect that they would get in this particular litigation they were involved in a very large sample size. And they were grossly overconfident because they compared their predictions with the actual awards they got in court. Secondly, there's a fair bit of research on, can you generalize from student populations? And you can generalize. Sometimes you cannot quite generalize the magnitude of the effect, but you can generalize that there is an effect. And the last point why students are a good thing is they don't suffer from things like incentive problems. For example, when you come to a lawyer and you say, I have a case, this guy hit me with a truck or something, very few lawyers will say, this is a rubbish case, you should settle it right now. Most of them will want to get a case. You want to win a pitch, and they want to work many hours because we know the financial incentives, if you pay by the hour, are to work many hours. And you have this kind of potentially unethical thing that can creep in. Students don't have this problem at all because there are no real clients. For them, what works is their reputation in the classroom, being seen as competent in front of their peers, and so on. So there's all kinds of problems that with real lawyers you would have, but you don't have with students.
Right, I'm going to stop you before you say too many bad things about external counsel and all the problems with incentives. But there are three key themes that I'd like to bring out today. One is the study relevant? And it sounds like it can be extrapolated to real life. So let's say it works. Is it relevant to our life? What are the practical realities and the impact and the potential drivers of this Myside bias? And most importantly, what do we do? What does that mean? And on the first theme, Lucas, can I ask you first, what do you think the study means for external lawyers? Do we have adequate systems in place to protect us, the clients? Is there a role in ethics? Michael said this has nothing to do with ethics. What do you think?
Yes, I think the study is relevant. But before I say that, whether the students are a good sample or not, let me go a bit further on that point, and then I will elaborate on the external counsel. I think, yes, there's no incentive in getting the client or getting money, but you always have the incentive of being proven right. And don't forget, most students are not married. And of course, people who are married know that you can never be right, especially if you are the male part of the marriage. But I think that's there's an element of prediction in expressing sort of what the chances of winning a case is, and I think that cannot be underestimated. Now, what it tells me is, and I think it's very useful that Michael put it in, Michael rather, sorry, I like to use it right, has put it very much from the very early slides, is nothing unethical about having bias. But where I think becomes relevant is that if we are aware that bias is present, it introduces a level of self-control. And I took it. Let me take a non-lawyer example, which I mean, lawyers, litigation lawyers, disputes lawyers are pathologists. People come to us when things have gone very bad. So think about sort of us as an sort of ICU doctor or an oncologist, where somebody comes and the tests say that this person has a stage 4 cancer. So the bias would be, the medical prediction is that you'll die in 4 months or maybe 2 years. But there's the other prediction is, I do the work I do to help people. Empathy comes as well as part of, I will put you on these sort of immunosuppressants, and I guarantee that although I cannot guarantee that you live forever, but you could perhaps live for another 4 or 5 years. And I think that's how the bias comes in. So that you get an assessment. I've seen 15 type of cases which are the similar fact pattern, but I think I can fight it. Not because I want you as a client, but because it's my task as a lawyer to do the best I can do for the clients. And there's nothing unethical about that. But how much my thought process works and what I communicate to the potential client, that's where ethics becomes irrelevant. And that's where you see very different things. I have Camilla next to me. A couple of years ago, I was talking to somebody who had a potential investment claim and comes to me. There was a particular problem with that investment claim, that this guy was arrested in the host state and he has pleaded guilty because he argues he wanted to get out of prison. Who would argue with that? But if you have pleaded guilty in court in that jurisdiction, how you can claim that you have an easy investment claim to be funded by a funder? And I said, look, this is very complicated. The chances are less than 50-50. You might be sort of designing. Goes to another lawyer. Oh, wonderful case. I will get it funded. And of course, you went with the other lawyer until sort of realized that actually, can we have you both as counsel? And that's sort of the two buyers getting together. So the doctor who tells you that you're going to die, and the doctor who tells you, I can't try an experimental medication. And I said, no, I can't do that. Because ethically, what I've told you is what it is. And I cannot work with somebody who doesn't have the same ethical code.
And I think, Lucas, also you highlight, there is, and I was kind of joking about it, but there is a sort of a number of lawyers that, are more critical about this case and are more critical and sort of are in the middle of the dotted line. So it's important to remember that. And Subert, if I can ask you, general question, what do you think the implications are for a company like Siemens Energy? But also, how do you, do we have the adequate protections in place? And do you, as a client, have the adequate protections in place?
There's quite a few things in there. Just before I get started, can I say thank you for inviting me. When you were introducing everybody here, I don't know if there's any Game of Thrones fans here, but I was just thinking of this scene where Daenerys meets Jon Snow for the first time, and she's introduced with like these 20 titles, Mother of Dragons, slaves, and everything else. And then Jon Snow is introduced as he's king in the north. And it's similar. I'm listening to people who've gone to Harvard and Oxford and so on. I'm thinking, God, I'm just from Stoke. What am I doing here?
It's okay to be Jon Snow.
To answer your question, coming back, I think bias comes in so many forms, and it's reinforced. And what you need is a process for checks and balances. So it's coming back to a practical application of our bias. I think there are limits. It's what you do with that bias. So the law and regulatory issues puts a limit on whether you can abuse that bias or not. And what I mean by that is, as lawyers, we will have duties to the court not to mislead and so on. So it doesn't matter how biased we are, how partial we are, we can't do certain things with that. But then when you look at it inwards, you have to assess, well, does that damage your case, your client, your business, and your commercial partners? And I think that's where the risks are. You have to start from, I'm an in-house counsel. I support my business colleagues, commercial colleagues, who will have a lot of emotional attachment and pride and everything else with a dispute and a project. They genuinely believe that. They're not making it up. My job is to assess realistically, and then a further step is an external solicitor coming in and assessing it and so on. Whether they buy into that, whether they're seen as pessimistic or optimistic. Now, it's natural, as Lucas said, you will want to go with the more optimistic assessment. You want somebody who believes in your case. And just this morning I was thinking, can I think of an analogy? And I think the only profession that's loathed more than lawyers are estate agents, and apologies to anybody who's an estate agent here. But I remember when I was selling my first house, I asked for 3 estate agents. I won't name the companies. The corporate is Reed's Rain. And they gave 3, selling price. 2 of them were within fairly close parameter. The other one was a lot higher. And I went with the higher one, as you naturally do, because you want the maximum you can find. But their get out of jail, when it actually sold for more or less what the other 2 had said, I remember clearly, it was my house in Sheffield, it was within a few £100 of what the other 2 had said, not the inflated 10,000. The get out there is, well, that's the market rate for your house. The fact that I pitched higher to get this isn't, you can't be held to account. Now, it's different dynamics with lawyers. I think no lawyer will ever guarantee a result. We know that. You can't. It's the unpredictability of litigation. No lawyer should sensibly ever give more than 70% prospects of success. And so whether you go with someone who says, well, you've got 65% success, or somebody like Lucas says, you've got 50-50-ish, the natural tendency is to go with the more optimistic person. But then you have to think, does that harm your case in any way? Because ultimately, you will win or lose your case based on the merits of what that impartial adjudicator, the judge or the tribunal, finds. And therefore, it doesn't, in terms of the outcome, I don't think that bias necessarily, in practical terms, affects it. Where it is very relevant is in the negotiations and settlement parameters. That is very much dictated by the enthusiasm or pessimism that's built in, and it can, it's not a good business model for lawyers to just come in and give you a very optimistic outcome if then you have to settle at considerably less, because there will be repercussions later on.
Or to the point, or you don't settle. And then you go all the way through litigation or arbitration. Your business has lost extra money, and you leave value on the table, kind of like in Michael's example. Camilla, I sort of jokingly said you're the money in the room, but obviously one of the things that you do is assess cases and whether or not they're valuable. Do you think this study is relevant to what you do, and what do you think the implications might be?
So for those in the room who don't really understand what litigation funders do, and Katya says it's my money, it's not my money, it's investors' money, and I have duties to the investors, and that is probably where the results are really important, and like Katya, I find concerning. So when we fund a case, what we're basically doing is paying the lawyers on behalf of the client, and that is essentially a non-recourse loan. So we only get a return on our investment, that being the lawyer's fees, if there is a recovery in the litigation. So we need to do a certain amount of due diligence and investigation into the claim, and to the best of our ability, work out if that claim is going to win. So a lot of us are ex-lawyers, but irrespective of that, the lawyers are going to know the case better than us, because they've gone through all the documents. We don't do the due diligence that the clients do. We don't go through every single document. We rely on the lawyer's views. So if there is this view that the lawyers are artificially inflating the value of a claim, that is really going to worry us, because if we are investing on the basis of an overvalued claim, then we are misrepresenting to our investors the value of their investment. And what we at Omni Bridgeway actually do is we do, on the basis of quite a complex decision tree analysis, we work out the net present value of a single dispute. We see a dispute like a legal asset, with value in it, and essentially we're loaning on the basis of the value in that legal asset. So if that has been overinflated, then that's a real problem for us. It's also a real problem for the funding industry, because it lets us down, and it doesn't make us look very good if we're funding cases on overinflated values. The other thing is, it really benefits us if a case settles, because the result, you are much like the cases we do better on, the cases that end up settling actually, and we want to fund cases that are going to settle. Our internal rate of return is also better on cases that settle, because you don't have these long protracted hearings and enforcement proceedings. So if we have a discussion with the claimant and the claimant's lawyers right at the beginning on their expectations around settlement, we're going to listen to what they're going to say. We shouldn't ourselves, before we've invested, have Myside bias. Talking to Lucas's point about wanting to be proven right, until we've actually made the decision that we want to fund in a case, we've got nothing to be proven right about. There is, I think we were talking a little bit in some discussions, there may be something about funders' bias. Once we've made the decision to invest, we potentially have the Myside bias, because it's in our interests to have a good outcome. But certainly before we've taken that decision to invest, we should be more independent in our views. So yeah, it's important to us. It is important.
I think, and you're highlighting a sort of almost impartial role in the industry that we're in, that the funders play. And many times I've said, look, your case can be funded, and in any event, you should test it with a funder. Because
you're using me, Katja.
I'm sorry. In a good way. but and we'll come back to that. The things that funders do, potentially because of this study, actually need to be replicated more broadly. Now, is that possible? Key theme number 2 is, what are the practical realities that we face? So you're on my list next. Practical reality of, you are Siemens Energy, you get a dispute, what do you do with it? What is your role? What is the role of external counsel? And I remember, I won't name them. They're in the audience, so I'll be careful. But someone had said to me, actually, my role is, to manage risk. My role as an in-house counsel is to manage risk. How does the study fit into that? What happens when you have a case that comes to you? How do you manage that?
I think the overall objective in any dispute is that you try and get the best result you can in the most cost-effective way. Now, costs can sometimes be completely disparate, sometimes they can be insignificant, depending on how many zeros are involved in the actual substantive dispute. And just following on from Camilla's point about overinflating figures, there is the danger of, I think, deflating the figures as well. I don't want somebody to come in who is over cautious and makes me write off sums or settle below things that I am entitled to, that is doing as much a disservice as somebody, like the representative estate agent coming in giving you an inflated value of the property. What you want as a lawyer in-house is a proper assessment of what it is, but you cannot exclude bias. And I don't necessarily, this is a personal view, I don't think bias is necessarily a bad thing. It's almost a semantic that you believe in that case and you're fighting it within limits. You've got to be able to see the other side's arguments, but that doesn't necessarily mean they will convince you that you are wrong. And if I can use a slightly different analogy, we engage experts. So many of these disputes will revolve around expert valuations, etc., etc. And if you see how courts treat experts and the issue of bias with how they treat lawyers, it's very different. So in the English courts, you have what's called Part 35 of the Civil Procedure Rules, and the experts cannot act on a no-win, no-fee basis, which lawyers can, for example. So they don't have a teeth in the game. They have to be seen as truly impartial and independent and aiding the court as opposed to the party that has hired them. And it's quite frustrating as a lawyer often that I can't have somebody who builds up a claim for me. I bring them in and say, look, what is my claim worth, let's say on a construction project? Can you build that up? And I can't then engage him to be my expert because the court says, well, he's got a vested interest because he built up the claim. And so I end up having to pay for somebody else who's an expert advisor, if you like, a dirty expert, I think is the phrase, and then the court, appoint for. And I think what that says is it's the issue of bias, that experts have to be much cleaner if they're going to be appearing in court or before tribunals than lawyers have to be. We are there to fight our corner. We are there to assess realistically what it is and put forward the best case. And, some of the barristers, King's Counsel that we engage, they're often a bit awkward and difficult internally when I'm sitting with my CFO and the project directors are thinking, God, why are you so, down about this, etc. It's to manage expectations. But then when I see them advocate for our case in front of the judge or the tribunal, they're more enthusiastic than any of the project team ever was. And that's a talent that people have to have almost Jekyll and Hyde to say, well, take this out realistically this, but we'll put forward that other case. As long as you're misrepresenting, I think that bias doesn't affect you.
I think so. So I think you're highlighting a really important point, which is the difference in roles, and we'll come back to that. But there is a role that counsel plays as zealous advocate, I think was the word, and I remember talking to one of my clients around bias, and I want a biased lawyer. I want someone who says you're going to win, even if I really know there are cats and dogs and various skeletons buried. I want someone who believes in my case, kind of what you were saying. Now that's great for the zealous advocate role, but it is actually detrimental to the objective advisor role, and I think that's the thing that is worrying, because then Siemens, if there's a zealous advocate and you get someone as a zealous advocate because you want them to believe in your case, that's great. But if then they, as the study shows, overinflate the figure, and on average they do, that leaves money and value on the table, because actually something that could have been settled doesn't end up being settled, and there are costs that are wasted. Lucas, can I just draw your thoughts on that? And, does the study show what you see in practice, and what do you think the key drivers are behind this unconscious bias? And I think that's the real key point here. This is not something that we think, oh, I'll just just move it away for my role as an objective advisor. I'll just suppress it. It's not something we control.
Super makes a very good point, which is sort of the lawyers are technically officers of the law or officers of the court, and there are certain ethical duties. But looking around the world, the standards of ethics vary quite a bit. I was trained in a jurisdiction, in civil law jurisdiction, where the first thing I was told by my pupil master is that your enemy is your client, because the client is going to give you a version of the story, the version you would like to hear, because they want to predict an outcome. While the reality is that once you go down the line and you investigate the matters, you will find a different view. That's why, for example, in a civil law context, you don't start the case unless you have collected all data. Unlike the common law, where you start the case with very little data, and as you go along, you build up the case. The outcome is, in the US, we have discovery, while we don't have it in Germany or in France, because you don't need to produce documents which are adverse to you, but you need to do a level of investigation of your case that you have the level of prediction. So I think, however, all lawyers have some ethical compass. Sometimes it's pure legal culture, sometimes it will be other aspects. But also what I think is quite important, and that's not necessarily reflected in this sort of type of studies, is how the views of the lawyers start between getting instructed and getting the thrill of getting the case to working down the line and the case changing substantially because you've seen the other side's case and then you have a slightly different view. So that's why I think a lot of lawyers will say, oh, well, you have 70% chances of winning the case. That's enough even for the funder to give you the money. And down the line, the 70 becomes 65 or 50 or 55, and then you hope that you'll get the outcome. Where I think I would find, there's a certain level of liberty and being external lawyer, not in-house, in the sense that in-house you have only one client. And if you need to sort of manage your risk and manage your sort of the expectation of the client, that's when if your client is, if your GC or CEO is very aggressive, that's when you have to instruct an external lawyer and have them tell the story that you were telling them, but they were not prepared. And the same as I think is for our lawyers. We do a lot of estimates on the case, both in terms of cost, but also in terms of expectations. And this has to shift. And I think at some level is good communication, which not everyone, I think there's a lot of pride, and I am using the word informative. There's a lot of machoism in law. I mean, it's not a gender issue, but it's a certain attitude. People don't like to be proven wrong, and they're prepared to sort of hit the wall. Now, from my own experience, what I find frustrating, because we talk about settlement, is that the cases which are perfect for settlement, they don't settle. Mm. And people, because sort of ego comes into the picture, you fight cases where you know that your client is going to lose, and you advise them to take the offer, you attack to go to the table, and they don't take it. But that's when sort of rationality is being sort of tempered by ego and other matters.
That's a perfect segue. Dan, if I can, I know you have a presentation, so it's probably easier for you to
sure.
Unless I can stand there and
I'll do it if that's okay.
Michael, do you mind helping just finding the presentation? Sorry, this is not rehearsed. But Dan, I think now that you've heard all these lay people's opinions about the drivers behind Myside bias, actually, it'd be great to hear from you on your studies in this.
Sure. So first, thank you so much for including me. It's an honor and the true pleasure to hear real people talk about these things. If I may first just make a couple of quick comments in response to things that have been said. Camilla, you mentioned correctly that you once you fund something, your psyche changes. And that's absolutely correct. Just technically, I would make a distinction between this bias and once you invested, you're subject to what's called the commitment effect. And and that's a very well established finding in the literature, and that's when the sunk cost fallacy is the flip side of it, right? Or it's the cause of it. So then you're subject to another bias, and maybe even a worse one, and that's why lots of people continue chasing bad money and such. The psychology is a bit different, but it's really important to understand that that's going to happen too, almost regardless of this initial sort of adversarial bias. So just a quick comment. If I were you, I would go with those awkward, nerdy barristers who kind of are sour on the case, and then they get up and fight. I'm with Michael, I believe, you don't have to be biased in order to make a good argument. And I think those are the people you should be looking for. And Camilla, I would invest in them too.
Barristers or advocate solicitors.
Sorry. So very briefly, I'll kind of come from the psychology side to just to supplement what Michael said. And this is not working, so I'll do it from here, sorry. So basically, I'm going to give you a bit of a broader view, which will complicate things. But what can we do? Life is complicated. So first, what Michael said is absolutely important. That's the heart of the problem, especially in this, the context of legal practitioners. But what I want to say is that there's a broader research program that's looked at other kinds or other aspects of this phenomenon that we're talking about. And studies show that once you're assigned to an adversarial position, you distort also facts and beliefs about the case. So you'll look at a particular fact and draw an inference that is consistent with your role. We find that emotions also get distorted by the assignment. You get to like or dislike protagonists and other participants based on your role. Importantly, the motivation towards case outcomes shifts to be consistent with your assignment. And this is a very important point that Michael said, is that we're talking here about what's called the lowest boundary conditions. There's just an assignment. There's nothing to be gained or fear of loss in these studies, and that's why they're purer now than real life, because they are incentivized with status and wealth and power and whatnot, right? So this is a much purer test. I think it's well taken, Katja. What Katja said is that, well, how do we know that it applies to the real world? I've got a super long answer to that, and I'll spare you of that because I'd like to show you some data. But and judgments, when you ask people who's going to win, which is similar to Michael's, what kind of judgments do you impute to your adversary who's completely fictional in these cases? And then how objective are you and how objective is your counterpart? Again, which is what Michael was speaking about, the blindside bias and the sort of the asymmetric view of bias, depending if we're thinking of ourselves and of others. So I'm going to skip the methods, and I will just say in a bunch of studies, look at the bottom section, people were assigned randomly to represent one of the opposing sides or given a neutral assignment, which is kind of you're part of the judicial team or you're helping the arbitrator. You're just trying to find an accurate outcome. And everybody's instructed to be fair and objective, and there are no incentives, as mentioned. And the results, if you just start looking at factual inferences, how do you interpret the facts of the case? So I'll just, for the sake of time, this is one of the facts that, and I'm going to present the results from the people in the three conditions. The gold color is representing Debbie, who's being sued by a university, and not important, the facts at the moment. But if you were assigned to Debbie, this is a fact that works in the favor, an inference in the favor of the university. You, on average, give it a 4.1 on a 7-point scale. If you were assigned to the university, you give it a 5.1. And the question is, what about people who are not assigned to a side? They're smack in the middle, and they always are smack in the middle. If you look at more facts, in this case, there are 13 facts combined, you get the same results. If you're looking about emotions, how do you feel towards Debbie? If you happen, again, you see the slope. That is, if you're on Debbie's side, you have fewer negative emotions. If it's positive emotions, you see the flip side, right? You've got more positive emotions towards your quote-unquote client. Motivation. This is motivation. It's just scaled in the direction of wanting to see the university win. So the Debbie people assigned to the Debbie condition are pretty low. They're much higher than those assigned to the university condition. And again, the people who are not assigned come out smack in the middle. Motivation is a crucial, from a psychological perspective, it's the driver of much of what's going on. When we talk about incentives, we talk about role identification, it really works through motivation. That's the psychological operative construct. And maybe, you know, I could show you more of this, but maybe I think we preserve time for other people. But the point is that, and this complicates the story, because it's not just that someone who finds themselves in an adversarial position is going to distort the final judgment. It's also, as Michael said, they're also going to distort the arguments. They're also going to believe that they're objective, but they're also going to be emotional and motivated in all kinds of, and motivation again is a huge source of bias throughout our lives. So it's a complicated, it's a complex, sprawling mindset that we get in. And that's why we can, you know, especially with the biased interpretation of facts, that's where we've also got to be worried about experts. I'll say that at least in the United States, where experts are more like guns for hire, they are highly susceptible to this adversarial, it's called adversarial allegiance. That is, they produce, you know, expert opinions that are highly skewed in the favor of the side who appoints them. Thank you.
That was fantastic, Dan. And I think
I'll just give it back.
I was going to ask you a question, but I can. but in that study that you performed, the facts were identical.
Absolutely.
That I find extraordinary, because not only, and I think this is the frightening bit. The frightening bit, if I'm right, is that intelligent, educated people were looking at identical information and thinking that they were doing the best they could. There were these differences.
Absolutely. So there is quite a rich body of literature in psychology that shows how biased perception can be. And perception is sort of just a threshold condition, not to mention processing and so forth. And in this case, the fact that I kind of skipped, just for example, right? The story was that the student Debbie was alleged to have cheated on an exam, and it's a disciplinary hearing. And there are other cases that have been done, like Michael's, right? And there was a fact that she sat during the exam, she was crouched over her papers. The university says she was crouched because she was hiding that she was teaching from a crib sheet. She says no, she was on the volleyball team, had an injury, and she crouches because it hurts. And then you ask me, but why do you think she crouched? Was it this or was it that? And again, so these are, and we're doing this all the time. When you're looking at a case, there are, tens or hundreds of pages of documents. Everything is subject to interpretation and misinterpretation. Kind of think Rashomon, and then everything else makes sense.
That's really interesting. And that very neatly, this frightening fighting, very neatly puts us into the third and final, before we open up to question, topic. And I'll let Dan join us back on the panel. But solutions. Okay, we are in this situation. Now what do we do? How do we tackle this potential bias? How do we make sure that the graph that Michael showed with the skewed, really frightening, settlement rates in situations where really a lot of cases can and should settle. What do we do? Camilla, I'm going to start with you because you've already been thinking about this as a funder. What are the things that you think work? And what should we be thinking about doing more?
Yes, so this study has really made me think about what recommendations I should be making internally about our procedures. And I would say I've come up with 3 important ones, most of which we are doing already, some which we need to give more thought. So the first is obtaining independent second opinions from lawyers not involved in the case and not likely to be involved in the case. So we'll make it very clear to them, we have a funding application from a claimant, these are the lawyers involved, these are the papers that we've been provided with, can you give us your opinion? And by the way, there's no opportunity for you to steal the case off the other lawyers. So the hope is that they don't have any incentive to overinflate what they think about the case. And we shouldn't just be doing that before we make the funding decision. Lucas was talking about that things change as we go through the case. It's what I'm learning the more I'm a funder, is that it's just impossible to ask a claimant right at the start of the case, can you provide us with all the documents? And by the way, can you predict what the other side is going to say and how this is going to play out? It's just too difficult. Even with all the papers coming up in the world, we don't know what the other side's really going to come up with. So not just getting an independent opinion at the start, but a good point to get an opinion would be at the end of the stages of the pleadings. So when we know how the arguments may play out before the hearing. So the second thing to say is potentially include in the budgets that we provide to the lawyers mock hearings. And we talked a little bit about this when we were preparing for this panel. And some of those who would work with law firms were talking about they present the case just before they go into the real hearing, presenting their case to a mock tribunal, to mock judges, getting the judges' feedback and adjusting case strategy on the back of that. And I think everyone was talking about that's really been quite a useful exercise where you've been able to have the time and the budget to do something like that. It's going to cost you, if you're replicating the trial, that's going to be about 2 weeks of work for everyone, but it may have some real value if you can afford it. And then the last one, I think we've been talking about the concept of just being aware is really valuable. Just knowing that you have these biases and that it's unconscious, and adjusting your behaviour accordingly should have some real value. And particularly in the case of settlement discussions, another really interesting bias that I came across looking at this panel was reactive devaluation in a settlement context. So you're having settlement discussions with your other side, and the other side comes to you with a figure way out what you thought they were going to, and actually probably somewhere within your comfort zone where you would be happy to settle. But because it's sort of been their opening shot, you've got a bias to go, well, hang on, if that's their opening shot, they must know something that I don't know, and that is your automatic bias is they know something I don't know. So I was interested in that as well. And again, in settlement context, it that sort of bias doesn't do us any favours.
I think that's brilliant. I wrote those things down, and I almost, for the third one, before I turn to you, Lucas, for the third one, this awareness, I wonder if there is, and this is a question, a discount factor, almost, that you could just apply, like whatever anyone
wouldn't like that.
Yeah,
the client won't
ever
like
said. But I think, and that's why an empirical study is so helpful, because then you say, right, I know you're not going to like it, but internally our system needs to apply it because the evidence shows, on average, we overvalue and our lawyers overvalue our chances of success. And in order for us, on average, to improve our chances of settling cases, we're just going to apply an X% discount. I'm not saying that's the solution, but I can see that this awareness raising, there are ways in which potentially you can just insert sort of mechanics into it. And the emotional side, I mean, Dan, that was fascinating because I know, and everyone who's an advocate here knows when you put a witness on the stand, you get to like them. Even if they're complete shysters, but obviously none of my witnesses ever were shysters. Mm-hmm. But you see their perspective and why they lied and cheated, and I caught myself a few times being like, hold on a minute, how is that possible? Kind of what you were saying, Lucas, but you pled guilty, how are you gonna? And with that, Lucas, again, we spoke about this in our pre-meetings, but we talked a lot about counsel role, and the things that we can do as counsel, and would really value your ideas on that. But also from an arbitrator's perspective, is there something that the arbitrators need to be aware of as well, from their own judgment of the case, but also from their own potential biases?
Yeah, I mean, I could preface that, but I mean, I know we are getting into an AI era, but we're not yet there. So decisions are made primarily by judges, having looked at sort of the case as presented by the parties in a sort of typical adversarial system. And I recall one of the books I was reading when I was a student by John Dawson called The Oracles of Law, referring to the judges. Because the problem is that you develop a case strategy, you provide evidence, and sometimes there's also decision makers bias. There's certain things that click with the judge, which is one of the documents you have there, which you don't think is the most important document, but that's the thing, or something that the witness said, and therefore you cannot always predict outcomes. It's a bit, and effectively, that in the US, there used to be statistics about judges, who is more likely to give you an interim injunction when you want it, and who is going to give you that level of damages in car accidents, and etc. Now, from an arbitration perspective, of course, parties put the tribunal together, and even if they have somebody who is reasonably biased or has a level of empathy with them, there's always a chair where you think that the chair will be more independent. And of course, people might remember this infamous case called the Owners of Steamships Catalina, where one of the arbitrators was disqualified because he was caught sort of saying in the coffee break that all Portuguese are liars. I don't believe that, actually. I like Portuguese people a lot. But that, of course, it was a shipping case. That's one of the things that you hear in passing, and that's classical scenario of bias. That's you kick out an arbitrator. But I think the problem we have, and arbitration, as I say, the tribunal can be reasonably balanced if the parties contribute, is asymmetry of weapons. And I think unless the case of a certain value, there's a lot of cases in between where one party is not properly represented or is underrepresented, and therefore a zealous advocate has a field day. And in arbitration particularly, you are not supposed to balance the unbalance, because then you're actually being unfair to the party that's presenting its case. So the other party could have presented the case, but they haven't presented the case. So in my first ever award, I wrote 2 awards, one on the basis of law, what you do as a young arbitration lawyer. That was, 28 years ago. So you 27 years ago, you put the case which is right on the book, like writing it in an exam paper. And then you write the award where you play all equities of the case. And I have to say, and I don't regret it, that I went with the black letter application of the law rather than the equities. I was too young, I didn't have any other option, and my award was technically correct. But I agonized for about a month from having drafted into that. And again, one party was not well represented, the other party was very well represented, but the outcome, what it was, we need these checks and balances, and we need it at different levels because it's in the big cases, one would expect that everyone's well represented. In the small cases, you get certain, and then in the small cases, you really can play the role. And being an active, sort of proactive case manager can sort of balance some of this imbalance without sort of breaching any. And I think because the arbitration, speaking of arbitration, the system of arbitration is you're paid typically at the end. You don't have the incentive to read into the case too early, and that's a mistake a lot of people do, because you really leave sort of things to the last minute, and then the damage is done. But one final thing I want to make: Queen Mary did a few years back a survey on the back of a PwC survey, which was looking at damages awarded in investment arbitration. That was 2015 and 2017. In 2019, we were given access to ICC archives. So we had a team led by now a professor at the Netherlands and 5 of our LLM students who looked at most of the awards to see how damages were awarded. And very similar, sort of the claimant's case and the respondent's case was in the 40s, 70s, or scenario that sort of Michael was sort of suggesting. And of course, that had a backlash about investment arbitration altogether, because the likelihood is you recover some costs and a bit more, but not the lost profit, not the whole case. And we've seen that sort of overinflating has a negative effect overall to the process.
Yeah.
And that's a really important point. And I think that one of the questions that I'd like to ask, and I don't have the answer, is what, if anything, can we do in the process of arbitration, right? In the process of litigation. Camilla mentioned timing. So we all know there's a time right before disclosure or discovery where you sort of check in and say, right, okay, are we doing this because disclosure is such an expensive task? Can we settle based on the arguments we've seen, etc.? And then there is an element pre-hearing, right? Post-disclosure. Okay, so now everybody has seen whether or not there is a smoking gun. Let's reassess the case, and what, again, assuming at all times we are all biased. That's just for the sake of it. Obviously, no one in this room, but others. What can we insert in the process itself that remains cost effective? And one of the things, and I'll turn to you, Suber, one of the things that I found really interesting in Michael's study is you can't fool yourself. You can't go, our unconscious is as smart as our conscious. So if we thought we were the defendant, then click, you see the tables one way. You think you're the claimant, click, and it's automatic, you're biased towards the other. And even understanding the arguments, it sort of reduces, but really it doesn't work. What did work is the sort of goal state. So suddenly you are no longer the advocate. Your job is to assess. And if you don't, there's a repercussion. And that, the sort of goal, the goal states, I think it's called in the study. How, Michael said it's difficult to replicate. How can we replicate it? And I think, Suber, you said before, we need to have checks and balances. You also said, really, there is no, and I'll turn it, I know you meant it positively, but actually there is no repercussion for a law firm that comes to you, and Lucas and I have had many situations where you come, you're trying to be realistic, and so as to force a settlement effectively for the client because you think that's in their interest. And another law firm or several law firms come along and said, don't worry about it, this is not a big deal. We'll do it really cheaply and we'll do it really fast, and it's not a big, Lucas is smiling. We've all been there. So what are the checks and balances that we can implement at Siemens? And this is more of a broader question. I'm not putting you on the.
I think there's quite a lot there. I mean, first of all, it's very difficult to recognize within oneself that you are biased or accept it. Related to this, I think there's been lots of studies done about memories, people's memory recall, etc., and how unreliable people's memories are. So if somebody's memory itself is questionable, then that sort of extends to say, well, they're not consciously being biased or unconsciously, that is genuinely what they recall. And the table example you gave, that's the genuine perception that they have. So there's very little you can do on an individual basis for that. What you can do is collectively, using the phrase checks and balances, to flush out those areas, those risk areas that emanate from bias. And there are various practical techniques that you can try. So Camilla mentioned earlier, in the US, they have, for larger cases, this kind of trial, if I can use that phrase, that you have a mock trial with arbitrators coming in or a judge coming in before the real thing. This is my personal view, not all of it is my personal view, not Siemens Energy's view. I don't necessarily believe in that. I think it's good rehearsal for how you're going to perform later, but as an indicator of what the outcome will be, I'm not sure I necessarily buy into that, because there are so many variable factors. The judge has a huge say, or the arbitrator has a huge say in the outcome. So the fact that you've got X as the mock arbitrator is in no way indicative that arbitrator Y is going to go that way. What you may do is flush out weaknesses and contradictions in your case and your case theory and so on, but you can't really predict the outcome through that process. And it is a very expensive process. And the second more important thing is, in the UK and other jurisdictions, you can't really have that process because you can't have witnesses being coached. You can't prep them what to say and how to answer questions, which is very different from the US, where that is very much the done thing, so there's that difference. And so I don't necessarily buy, certainly for the UK, maybe different in the US, that necessarily adds value. It may test out and flush out inconsistent weaknesses, but it doesn't make allowance of bias. To answer your question, I think there's a number of processes. So one, as I said, normally there will be those people who are intimately involved with the project and the issue, and they have a lot of emotional attachment. You've then got to go to those who are detached to it, and within organizations like ours and many others, I derogatively call them the bean counters, but they're the ones that come in and look at the financials and say, look, whatever your emotional attachment to this might be, this is what works as a deal, as a settlement. And then there are mechanisms to make allowances for biases, whether you recognize it or not, and that is the settlement option. So you can say, a specific example, in the UK, you have what's called Part 36 offers, which means you make an offer that the judge doesn't know, and there are consequences flowing from that if the other side don't accept it, whether you're a claimant and defendant. So you could make allowances for your bias and say, look, my claim is worth 5 million, but taking all these risk factors into account, including the possibility there might be bias, we will offer to settle for 3 million. And if the other side does a similar exercise, then the idea is it should narrow the gap to a point where you may settle. But ultimately, if you don't, it's down to a third party, independent or impartial person like Lucas to come and say, well, X was right or wrong. But can I just say this final point? The result of a case, let's say you don't settle and it goes to a judgment or an award, will not automatically make an individual or a party reappraise their position and accept the outcome. They'll have to accept in terms of payment out, etc., but they don't necessarily have to accept that that was the right result. If anything, people can be even more entrenched when they see a judgment and think, actually, no, I still believe I was right, and the judge was simply wrong. And the proof of that is a judge's finding is a personal opinion based on the facts and evidence that he or she has seen. But that's why you have Court of Appeal, and then you have the Supreme Court. So the notion that, oh, this was down to bias or we got it wrong because the wrong result came in, wrong result in the sense that it's not the result we were hoping for, does not automatically negate the position you took, and it can't be down to bias.
And I think, and Michael, I'll come to you in a moment. I think what you're capturing here, Subir, is the probabilistic valuation of a claim. So what Camilla was talking about, fair market value of the claim, the expected value of a claim today, based on what we predict will happen in the next 3 years, that's a probabilistic estimate. And I think the key here is, do we think today, at those key junctures in the case, we will have a better than not chance of winning? Frankly, that's what it boils down to. And who makes that assessment, and when do they make that assessment? And that's the really interesting bit. And how do we make sure that the people making that assessment on a probabilistic basis are non-biased, or at least we factor in that bias. And I think it's an important point, because a lot of people don't understand, if I say 60-40%, it doesn't mean 100% of the time you will win. It's a probabilistic, and then impacts the expected value that you're intending to get, which then impacts settlement. Michael, I know you were smiling.
I want to say one interesting thing and one thing that I think, So the interesting thing is this: the goal state manipulation, the one that worked. We thought, okay, if we looked at some theories about how the brain works, and we thought the only way of getting rid of this is make people not advocates for this task, have them be appraisers. So we said we're going to tell them there's an objective estimate to which their estimate will be compared. And we said this is AI made, and there was no AI estimate. We just threatened them that there's one. And the second, we said you will be punished if you mess it up. So two components. There was an objective estimate and punishment. And the objective estimate was important because we thought some of this bias may come from people being overconfident how good advocates they are. If they think there's a judge, I am such a brilliant advocate, I will sway them. But there's an AI assessment, you can't sway that. So there's one. And the punishment because punishment. And then we thought, which part of this is really necessary? So we repeated the study. Once we did it just with an AI estimate but no punishment, and once we did it with just punishment but no objective AI estimate, and neither of them worked. Okay? That's the funny thing. The second thing, that's why I said it's difficult to implement, because we're kind of struggling how to do this. The second bit I think is relevant in terms of conclusion is this. Kahneman has a really, really cool example in his book Thinking Fast and Slow. And he shows not the tables that I showed, but Miller-Lyer illusion. I'm sure you've seen it. There are two lines, and they have fins attached to them. And once these two fins are pointing outwards, and once they're pointing inwards. And that's an illusion because it makes you feel like the one that points inwards is shorter than the other one. And it's the same thing. And Kahneman uses this exactly for the same purpose as I did. But what he says is, what can you do about this? Because whenever you look at them, you won't be able to judge. And he says the only thing you can do, and this is relevant in this bias context, is know and remember that your intuition is not to be trusted when lines have fins. And that means once you know that there's a lot of empirical evidence that in this kind of assessments, on average people are biased, you can't trust your judgment, not blindly. So you need to use decision-making tools. You need to have objective appraisers. You need to have someone external whom you don't tell who is buying your claim, who's funding you, and so on. You don't bias them in any way and put them in this objective advisory. I think that's probably the lesson. And obviously, it's not unethical to have a biased opinion because you're a good advocate. But it may be unethical to proceed with this opinion now that you've seen the evidence. You see what I mean? Like now you know that in these kind of situations, your judgment shouldn't be trusted. Is it ethical to rely on it? I mean, that became a full circle now. But yeah, this is all right.
Camilla?
All these really clever things. Do you know the elephant in the room that I keep thinking no one's mentioned is, what is AI going to do about
Exactly.
all of this?
Yeah.
And is this just, are we just sort of, sitting here promoting AI tools here?
And I think, and
No, I mean,
Yes.
yes,
I think there should be a mandatory court function for people who put a claim in to have some sort of AI-driven, like large language model, but with RAG, to kind of predict the settlement, give you expected value distribution of outcomes, not like an outcome, and then you can settle on that on a neutral expected value basis, or you can hire an advocate who can be as biased as it can be, because it's not their role to predict anymore; it's their role just to advocate.
and
I think we should do.
So Bert, go ahead.
Can I say quick,
Very conscious.
until AI replaces all, the one comfort we can take is either side can take the comfort that whatever limitation, constraints, and disadvantages they have from bias, the other side will have as well. They're humans still; they're not replaced by AI. So, whether it's me within Siemens Energy or the opponents, etc., they'll also have the same challenges and risks that we do.
Yeah, and what's interesting is you'll be able to predict their challenges better than them, and they will be able to predict yours better than you. Dan, and really this is the last one, because I do want to turn to the audience and we are running late, but I can't.
I can skip it.
No, absolutely not.
So there's something that I think both Camilla and Lucas mentioned that could be important. The results in Michael's studies, including my own, and I've surveyed the field, it's true for lots of other studies, is that at a snapshot in the beginning, you've got this polarized, distorted view. But we know in real life that at the end of the day, most parties are going to settle somewhere in between. So really the question is, how do they get from there to there? And I'm thinking that your job should be to try to facilitate and expedite and shorten that, because the litigation is costly and it's wasteful. So I would go along that kind of thinking. And picking up on what Camilla said, you mentioned the reactive devaluation. So that is one of the textbook biases that negotiators bring with them to the table, and they falter because of it. And it's actually even worse than you were intimating before. I'm happy to chat later. There are a number of very well-established biases in negotiations specifically. People start to polarize. They think it's a zero-sum game. They don't look for constructive sort of solutions. And there's a whole list, and it's very well researched, and including reactive devaluation. I would recommend that you expose yourselves and your colleagues to these biases and see how you can pull the levers just to cut back on that very lengthy, tedious, and costly process of reaching a settlement.
That is a wonderful, wonderful way to conclude this panel. And I think what this has done, I hope, and I'll turn to questions, is really trigger a sort of self-evaluation moment. And it looks like there may be processes that we can implement, and there are things that we can do, but we need to be mindful of cost. We need to be mindful of the process itself, that it is not biased. There's, Michael mentioned, and Camilla, decision trees, decision analysis, include a sensitivity analysis, as we often do, just to stress test what it is that is going to trigger, the win for the other side, and then test yourself of how likely that is. And just being aware of it, walking away and thinking, okay, I'm not doing anything wrong, but it is likely that I'm going to be facing this situation. And how do we move forward towards, sort of limiting that red line in cases where settlement is appropriate?